Good morning and welcome to this MERS Quick Bite webinar where we'll cover the topic of estate planning. My name is Leah Flores and I'm a Benefit Education Specialist with MERS, and I'll be here today to answer any questions you have related to your MERS benefits throughout the webinar. A few quick notes before we get started. Throughout the presentation, you can submit questions using the Questions tab, but I do want to point out, however, that this webinar is meant to be informational in nature, and we will not be able to answer questions related to your personal situation or offer you individualized advice. With that, let's get started. With us today, we have Thomas Fabry. Tom is an attorney with Clark Hill, where he specializes in topics of estate planning, probate, charitable planning, estate and trust administration, and related tax matters. This morning, Tom will walk us through some of the key points we all should be aware of when it comes to creating and maintaining an estate plan. So now I'll turn it over to Tom.
Good morning. Happy to be here today to speak to all of the attendees and participants. As mentioned, I am an estate planner with Clark Hill PLC out of our Birmingham office. I'm a partner in our personal legal services group, and I help individuals plan for incapacity and disposition of their assets upon their death. And for today's presentation, I've prepared a PowerPoint presentation addressing some of the topics that are important and should be considered when putting together an estate plan. The agenda for today will cover generally estate planning objectives, what is probate, what every estate plan should include, ways to avoid probate both following your passing as well as during your lifetime, some of the don'ts of estate planning, and general reasons to review and update your current plan. Why now? Why should you address your estate plan? For one reason, there needs to be a plan in place to control the disposition of your assets following your death. And in some instances, there are false assumptions that clients hold, those being that maybe because I'm married, my husband or wife can make decisions for me, or because I'm married or have next of kin living, my assets will automatically pass to my family. And those are some bad assumptions that result in scenarios post-death that can be confusing, complicated, and expensive. Another reason to plan now is because you have the ability to make informed decisions. And if you need to make tough decisions as far as maybe cutting out a child or disinheriting a child, or setting up a plan that is restrictive in nature, we want to make sure that individuals that are affected by it don't have the ability to challenge your plan. So while you have capacity, it's a good time to start planning. Some reasons people don't plan is, again, I've mentioned, false assumptions is, well, I have family members that are close to me, they can make decisions for me. Another excuse I hear quite often is, well, I just don't have enough in assets to warrant an estate plan. Other reasons are, I'll get to it eventually, or it's going to take up too much of my time, it's too expensive. Or I did that years ago. I sat down and I did a will in 1991, and that should cover everything. And I think the biggest reason is, as humans, we don't want to contemplate our own death. But I can tell you that you are doing a disservice to your family if you don't take the steps to have a plan in place, again, because probate is expensive, and once you're gone, we can no longer ask you questions about what you intended or what you wanted. Some estate planning goals, it's important before you move through the process to identify exactly what it is you want to accomplish. And we tell clients to identify the acronym goals. So get a plan in place for incapacity. Who would you select to make decisions for you, essentially to step into your shoes when you no longer can? Objects. Where do you want your to whom do you want your property to go to, and when? Do you want to set up certain conditions or restrictions on when a beneficiary can receive funds? Avoidance of probate is important. Again, we'll go through this a little bit later, but the ability to keep family matters private, the ability to avoid fees associated with probate and paying attorneys. Limit your estate tax liability. For some people, this may not be an issue, but there are excise taxes that are enforced against transfers of property upon one's death or during a lifetime for certain gifts. The law changed recently where this is now not a problem for most of us, but there are plans that can be put into place to limit an estate's liability to estate tax. Also, we want to have an individual in place when you have passed on that you trust to administer your estate, and their role as personal representative or trustee would be to marshal your assets, meaning to gather them up and to distribute them as you've intended and set forth under your will or trust agreement. So you hear a lot of practitioners speak about avoiding probate. Well, I think we should start with what is probate. And probate is the legal process through which a decedent's debts are paid and assets are distributed. It's a formal process where the individual nominated under your will open up probate in the county where you were last a resident of at the time of death, and the court will then issue what are called letters of authority, giving the personal representative the ability to conduct business on behalf of the estate. And there's a period of time during which creditors of your estate or the individual would have the ability to come forward, and the personal representative would be the point of contact and the individual responsible for negotiating those claims to make sure that when the assets are finally distributed to your beneficiaries, the personal representative doesn't have to go back and claw monies distributed to the beneficiary to settle a claim. Now, what types of assets would end up in a probate estate? These are types of assets where there's no beneficiary, there's no joint owner, it's not held in a trust, or you'll see with business interest. But if you have a real estate, we'll give you an example, your residence. If the residence is solely titled in an individual's name, so there's no joint owner, that becomes a probate asset. If you have a bank account that's solely held in somebody's name, again, that's a probate asset. If you have life insurance, 401k, an IRA, a 403b, where you have not identified a beneficiary on that account, well, the organization that is the custodian of that asset cannot pay it out to your husband or wife just because you're married, or your children just because you have children. They're going to look to the beneficiary designation as a contract, and they're going to respect the beneficiary named. If there is no beneficiary named, they will pay it out to your probate estate. So why do you want to avoid probate? We've addressed this a little bit earlier, but I can tell you that probate can become expensive due to legal fees, executor fees, as well as court costs. And the court will impose its own form of tax on the value of your estate to the extent there are probate assets. Probate is also time-consuming. At a minimum, the probate administration will last for at least 5 months. It's a Michigan court rule that states that prior to the closing, the court will require you to keep the estate open for a 5-month period in order to deal with certain affairs of the estate. Specifically, they want to give creditors the ability to come forward during a certain statutory creditors period. Probate also results in the lack of privacy. Personal information is posted on the court's docket, and it's kept in a file. If there's a will, the will becomes public. If there's a dispute that results from a contest of a will, let's say, all of the papers that are filed with the court become public, and you lose control over the process. So there are ways to avoid probate, and a good estate plan should do so. But that consists of having a foundational estate plan put together containing several documents. You'll see in a well-prepared estate plan typically a last will and testament and a pour-over, and I'll talk about what that is in a second, a revocable living trust agreement, a durable power of attorney for property or finances, and what we call in Michigan a patient advocate designation. In other states, you'll hear durable power of attorney for healthcare or healthcare surrogate forms, but here in Michigan, again, referred to as patient advocate, and a HIPAA release, as well as other documents such as assignments of tangible personal property and possibly a deed for your real property holdings. So what is a last will and testament? A last will and testament is a legal document that allows you to designate the persons or charities that are to receive your probate assets upon your death. It discloses certain requests for your funeral or burial, whether you want to be cremated or you want a specific ceremony held for you post-death. You get to decide how and when that occurs through your will. You also have the ability to nominate a personal representative or executor. Additionally, if you have minor children, the will gives you the ability to appoint the guardian and conservator of your minor child or children. In the absence of a will, there's a statute that controls the priority for the appointment of a personal representative and or a guardian and conservator of your minor children. The standard for appointment of guardian for minor children, and this is typically where we'll see younger couples who want to make sure that a specific person or couple is identified as the guardian for their children. They'll name it in their will, but if the will does not exist, one of the standards under the statute is anyone concerned with the welfare of the ward, being the minor children, has the ability to petition the court for guardianship. So we want to be able to preempt that statute pursuant to your will. So you can name whether it's your parents as the guardians of your children, your minor children, or a trusted friend as the guardian. We want to be able to make sure you have the ability to select, not the court. If you die without a will, the state of Michigan has a statute that controls the disposition of property. This is referred to as our intestacy statute. And for most people, a surviving spouse becomes the primary beneficiary of an individual's estate. However, I can tell you that for an estate, let's say that has $500,000 in it, the surviving spouse may not end up receiving all of the property. The statute in Michigan reads that the surviving spouse, where the couple has descendants of their own, children, will receive the first $150,000 and then half of the remainder. The other half actually goes to the children. So there could be a result where you intended for your surviving spouse to receive everything during his or her lifetime, but now because there's not a will or trust in place, your minor children end up with some of the estate. Again, the will also allows you to identify a personal representative or by nomination or the guardian and conservator. A common misconception that clients have is that if I have a will, I will avoid probate, and that is completely false. The only thing the will does from a standpoint of controlling assets is it trumps the statute that Michigan has, again, that being the intestacy statute. For most of our clients, we recommend that they create what's called a revocable living trust. And a revocable living trust is a document that contains instructions for what you want to happen to your assets when you die or when you become incapacitated. Assets held in trust for your benefit during your lifetime, so you're still the owner of the trust assets. You'll serve in the capacity as what's called a trustee, as the settlor, meaning you're the individual who established the trust, and as the primary beneficiary during your lifetime. A trust allows individuals to avoid probate following their passing. Some other benefits of a trust, including the avoidance of probate, is that you can control where your assets go. Again, if you have minor children and following a surviving spouse's death, you want to keep assets in trust for your children until they turn age 35, you can certainly do that. There are a multitude of options available to clients when planning for continued trust for their children. We can restrict it to be held in trust for their lifetime, or just have a certain amount distributed per year, or maybe just create a discretionary trust where it's available to provide for education or health. And in some instances, you'll see clients with children where they have special needs and they qualify for state or federal benefits. And we want to make sure that the inheritance doesn't disqualify the child upon a parent's passing. And we can create a supplemental needs trust. And there are conditions and restrictions that we can place or play into your estate plan to make sure that we can protect your assets from recapture by the state of Michigan or another state that you may move to. The trust also allows individuals to avoid some of the additional costs that result from probate. Another consideration that clients should take into account is that if you have a trust during your lifetime and it's properly funded, and if you become incapacitated later in life, your trustee can manage those assets for you, again, outside of probate. It avoids the appointment of a guardian or conservator for the individual. And again, that's a good thing. It also provides the necessary privacy that I think families deserve and want following an individual's death or incapacity. In addition, a revocable living trust allows for the consolidation of all of your assets under one plan. Meaning if you create a deed for your residence and you convey your interest to a trust, and if you change the owner of a bank account to your trust and you name the beneficiary of a life insurance policy to your trust, then upon the individual's passing, we now have all of the assets in one bucket, so to speak, being the trust, and the trustee has the ability to dispose of the assets as set forth in the trust instrument, which makes it a more efficient process. As mentioned, there are provisions that can be placed into the trust to protect from creditors of beneficiaries, to protect against disinheritance, disqualification under certain state or federal programs. And I think it gives the settlor, being the individual who created the trust, peace of mind that they can put in writing exactly what it is they want to accomplish without the intervention of the court. Again, a common question that comes from clients is, if I have a will, do I really need a trust? And as mentioned, a will does not avoid probate when you die. A will only preempts the state statute on the disposition of your property upon death. The living trust will avoid probate, and once you create the trust, you have the ability to amend or revoke it, so that it's flexible and it's fluid and it takes into account changes in your life circumstances. Again, a will does not offer the same protection that a trust does from the standpoint of if you become incapacitated during your lifetime, a trust, unlike a will allow you to administer those assets for your benefit during your lifetime. The will does not. It's not effective until your passing. So if we transition a little bit here, why would the court get involved in your affairs during your lifetime if you became incapacitated? Well, one reason would be if you do not have estate planning documents and you're unable to manage your own financial affairs or give informed consent to a doctor or maybe another treating physician, the courts are going to look to, or those individuals are going to look to the family to say, do you have a durable power of attorney for finances? Or do you have a designation of patient advocate? If you don't, the court or the hospital or treating physician will then say, we need you to appoint a guardian or conservator to make these decisions. And that process is time consuming. And if there's a need to make an immediate decision, it creates an unnecessary hurdle. Again, upon an appointment or petition by a family member for appointment of guardian, the court gets to control who's going to be making decisions for you from the healthcare standpoint as well as from a financial standpoint. And I can tell you from experience in dealing with these matters that when you have families, maybe it's a sibling group, and there's some concern or argument about who's best suited to make decisions for mom or dad, the family's situation then becomes open to discussion before the court. And I've seen a lot of families spend a lot of money trying to fight out who should get appointed to make decisions for mom or dad. And it's an unnecessary cost when a client can have a document put into place that can nominate an individual to make those decisions in advance. And if you give me a second here, I see that we have a few questions coming through that I'd like to maybe answer one or two of them. So I have a question: is the trustee the same as the executor of a will? And to answer that briefly, no. The executor, or also known as a personal representative in Michigan, is only nominated under a will and can only act on behalf of your estate. The trustee is the fiduciary of the trust. And if we fund the trust properly, meaning we identify the trust as a beneficiary of your life insurance, and the trust owns the home and owns the bank accounts, we should never have to have a probate estate, and the trustee should be the only fiduciary involved in the administration. Again, the personal representative would only act on behalf of the probate estate, which we want to avoid, so hopefully they never have to act. Now, that does not mean that you cannot name the same person to serve in both roles. It's just that they serve different functions. Again, continuing on how to avoid court involvement during your lifetime. Well, again, using a revocable living trust, which can be funded during your lifetime, and that while you have capacity and you can make informed decisions and manage your affairs, you are the trustee, the settlor, and the beneficiary. And I like to think of them as being the CEO, the CFO, and the main shareholder. You get to be the boss and determine when and how you draw money out of your trust. But when you can no longer make those decisions, your successor steps in during your lifetime and manages those for you. Again, upon your passing, that successor trustee steps in and manages the property for the benefit of your named beneficiary. Another document that we have as part of our plans is the durable power of attorney for financial matters. So the durable power of attorney is applicable to non-trust property, and you have the ability to appoint your agent, or in Michigan called your attorney in fact, to go out there and act in your best interest with the intentions of dealing with third parties. So, for example, if a client has a bank account that's in their name, solely in their name, they never got around to naming the trust as an owner, and they don't have a joint account owner on it, the attorney, in fact, by using a durable power of attorney, can show to the bank the legal document and then can have access to the account. Now, there are certain restrictions on what can be done, but for all intents and purposes, the attorney, in fact, would have the ability to write checks on the account. They would have to render an accounting, so meaning that they need to be able to show whether it's you or another individual that they're acting in your best interest by reconciling what came out and for what purposes. But they would have access to the account. A durable power of attorney, though, extinguishes or terminates upon the principal, the person who created its death. Another document is designation of patient advocate. Again, it's a way where you get to identify during your lifetime an individual that can make healthcare decisions for you, placement decisions for you, and end-of-life decisions for you when a doctor determines you cannot give informed consent or cannot make decisions in your best interest from a healthcare standpoint. I'm going to field another question here quickly. If an individual has a trust and passes away and distributes assets to their children, does any liability on these assets transfer to the individual whom the trust lists as the beneficiary? And that's a very good question. The answer is maybe if the right steps aren't taken by the trustee. So when somebody passes away and they come to me to say, the trustee comes to us and says, what should we do? Well, the first thing we want to do is have the trustee publish a notice to creditors. So that publication will go in the county newspaper. So if we're in Wayne County, let's say, we'd publish it in the Wayne County Legal News or the Detroit Legal News. And the publication would state the date of death, the name of the individual, and generally state that creditors of the estate or trust have 4 months to come forward. Otherwise, their claims will forever be barred. And that's intended to deal with general creditors. Now, if there are creditors that we know of, maybe there's a hospital bill that's presented, we need to deal with it. To take it a step further, assume that the trustee negotiates certain claims, the creditor period has run, and there are then no outstanding liabilities. Well, when we distribute money, the beneficiary should feel a sense of certainty that there's not going to be a clawback. But if a trustee doesn't do that and just distributes the money, those liabilities will run with the property, so that the beneficiary may be in a position where they have to deal with the creditor. Now, there are certain assets that are exempt from creditor claims. Life insurance is one of those. IRA assets, certain retirement assets controlled by ERISA are also exempt from creditor claims. So if your estate is heavy weighted in that type of asset, maybe it's a little less of a concern. But we always want to instruct a fiduciary, being the trustee or personal representative, to publish the notice to creditors so that we can accelerate claims periods where creditors can come forward to that 4-month period. That's very important to make sure that when you're distributing money, your beneficiaries don't have to be worried about giving it back. Okay, so continuing on with the PowerPoint here. So how do we use a revocable living trust during your incapacity? Well, again, you've created this trust, you've put assets into the trust, and now you've become incapacitated. Your trustee, as the fiduciary, has authority to control those assets, to make distributions to you. If it's later in life and we need to have placement into a senior living facility, the trustee can work with your patient advocate to get you placement in a suitable location and then make distributions from the trust either directly to the facility, or maybe the older individual wants some spending money, can make distributions to the older individual. But it's a way to make sure that the court doesn't get involved in that process. Again, speaking to what a durable power of attorney is, it's a legal document that's going to allow the individual that you select to act as your agent out in the world. It's important, I think, when creating an estate plan to identify the important people in your life, whether it's, your typically spouses are naming each other to serve in the primary attorney-in-fact role, but think next level. If my spouse isn't there, or my sibling that I trust is not there, who else in my life can I look to act as I would act in the world? And this is a very powerful position, so it deserves your attention, and just not identifying your oldest sibling because they're the oldest. Sometimes it's not a family member. I've seen people go outside of their family to maybe their CPA or their long-standing friend. It just needs to be somebody that you trust. Even if people are out of state, I wouldn't let that affect your decision. I think that with the advancements we have and the way we communicate, it's okay to select a fiduciary an attorney, in fact, that's in California, because of the ability to almost instantaneously communicate with each other. Again, as mentioned, the patient advocate document, again, is a way to avoid the court selecting a guardian to make medical decisions for you. This is going to allow you to, during your lifetime, identify the important people in your life, the people you'd want to make care decisions, placement decisions, or end-of-life decisions, and you get to identify that. You also get to identify advance directives in your patient advocate form. So when it comes time for end-of-life decisions, you can specifically identify in that document whether you'd like to continue receiving life-sustaining support in the form of a hydration or feeding tube or respiratory assistance, or maybe you've made the decision that if I'm in a vegetative state as determined by my treating physician, I don't want the life-sustaining support. It's your time to or it's your way to let your patient advocates know what you want. And again, very important decisions, so that when that issue surfaces, your family's not stuck in a position where A, they can't make a decision, or B, they don't know what to do. So selecting the right fiduciary, whether it's your personal representative, your trustee, your attorney-in-fact, or your patient advocate, selecting the right person is incredibly important. Again, looking at the primary as well as looking at the successor, and possibly even a successor to the successor. It should be somebody that you have the utmost confidence in, the utmost trust in, somebody that's knowledgeable. They don't necessarily have to be a CPA or an attorney or a doctor, but it's somebody that's going to be willing to analyze situations, identify what the issue is, deal with the situation, or reach out to third parties to help or assist them with the situation. Whether, if your trustee has a dispute with a creditor and the trustee's not getting anywhere with the creditor, the trustee should reach out to an attorney. Or when the trustee needs to file an income tax return for you, the trustee should be working with a CPA to make sure that they're closing all the gaps, and that from an administrative perspective, they're doing all the right things. Family members can be a suitable choice. It sounds honorable to be a trustee, but I can tell you it's a lot of work. It's time consuming. And you are, as a trustee, you owe a fiduciary obligation to the beneficiary. So you need to be doing your job. Otherwise, it could open you up, or your nominees up to liability. Outside of individuals, we have certain clients that look to corporate trustees. And in Michigan, you'll see a whole host of corporate trustees, from banks to organizations such as Plant Moran Trust, or big banks like Bank of America or UBS. They offer these types of platforms. With corporate trustees, They charge a fee for their services, but administratively, it's an efficient process. They know what to do and how to check the boxes, and they don't get caught up in maybe the emotional side of telling a beneficiary, no, you can't have your money yet. And it in some instances is a good outlet for clients where the client foresees maybe some struggles following the client's death with beneficiaries, whether it's because of creditors or the parent sees that this marriage really isn't going to work out for my son, and I want to protect his inheritance, or a child with substance abuse, or again, supplemental needs trust. There are a multitude of factors to consider, and maybe a corporate trustee makes sense, maybe not. So some of the do's and don'ts of estate planning. Don't do your estate plan by yourself. More and more you'll see individuals looking to LegalZoom or just kind of handcrafting their own will on a loose leaf sheet of paper or typing it up on Microsoft Word. I can tell you from experience that those documents cause a lot of problems. They can actually add to cost because maybe they're not executed properly under Michigan statute, and now we have to have a petition before the court to get it approved. So I do believe that it's worthwhile to invest in an estate plan. A common scenario we see is people trying to avoid probate or avoid having an estate plan by having a joint account with a child or many children. This creates a problem in the sense of if a client has 5 children and they name one child on the joint account with instructions to distribute the property equally to the remaining children following the client's death, well, you've said it, okay, but that's not binding. Number one, there's also a presumption that the account was established to be a joint account so that the remaining joint account holder owns it all themselves. And there's no binding promise by the surviving joint account holder where they now need to distribute it out. They could just take the money if they wanted. So that's not a great plan. In some circumstances or instances, does it work out? Sure. But we've seen enough cases where it doesn't, and that gets expensive. Don't falsely assume that you have a beneficiary of your 401k, an annuity, a life insurance. Go through the process of identifying with either the custodian or the asset, the organization administering the asset, to identify that a beneficiary is actually named. And it's a fairly simple process. Typically, you could reach out to, if you have a financial advisor, just call them and say, hey, I want to know who the beneficiary of this account is, or I want to add a beneficiary. These are your assets, so you have the ability to control. Also, again, the idea that you don't have $1 million, therefore you don't need an estate plan, it's wrong. Everyone needs an estate plan. Anyone over the age of 18 in the state of Michigan should have an estate plan. Because at the end of the day, if they don't have even simple power of attorney or patient advocate, a mother or father just can't make a decision for that 18-year-old. The court will say, if you don't have that patient advocate or power of attorney, we're going to appoint a guardian and conservator for you to make those decisions to the extent you can't. So again, it's important to have this in place. If you have an existing estate plan, when should you review it? When should you update it? I think in common practice, every 2 to 5 years, it makes sense to address your estate plan, to take a look at the beneficiaries and the age of distribution and the fiduciaries that you've selected. Are they still in your life? Are they still alive? How's their health? Do they have any of their own problems that maybe you don't want to burden them with administering your estate, or maybe their problems could result in them doing a poor job of administering your estate? Life events such as marriages, you've won the lottery, you sold a business, you've retired, you have grandchildren, you want to benefit a charity, these are life events that would promote clients coming to see us. And what I tell clients is there's mutual obligation in working with each other, and it is a very personal relationship serving as an estate planner. When there's a change in the law, I'm going to let the client know whether it's a change in the tax code provisions or a change in the state law that affects how we interpret trust instruments. We will certainly let clients know. But if there's a change in the client's life, we won't know unless they tell us. So again, the mutual obligation to stay in touch. Again, I think if we came back to the core concepts of estate planning, and it's a general broad subject, we could discuss it for hours. But when you're looking, why do you need an estate plan, to wrap this up, as incapacity planning and planning at death to avoid probate it's pivotal. From a family planning perspective, being able to control to whom and when your property is distributed is important. Minimizing estate and maybe income taxes is also important, as well as being able, to an extent, to control from the grave, so to speak, and having the ability to participate in that process and being able to understand what your intent was when you're no longer here is important. I know that we have, and that's the conclusion of my slideshow, but I know that we have some questions that came through that we can answer here. And I believe Leah is still on the line, and we can go through this process here of picking out a few.
Yes, that's correct, Tom. I'm still here. And first of all, while you're looking at the questions, thank you so much for your time and this great information.
You're very welcome. It's my pleasure to be here. So I'm going to just pick out randomly a few, and if there are any follow-up questions, my email is, again, located on this last slide. It's still up. Generally, if you have questions, please feel free to shoot me an email, and I'll try my best to respond timely. But I'm going to read a question here from, is there a concern with having two fiduciaries, one for financial and one for medical? No, and that's a very good question. There does not necessarily need to be parity in fiduciaries, meaning your healthcare, your patient advocate can be different from your attorney-in-fact or your trustee. In some instances, a spouse is an ideal candidate to be your patient advocate because they know you better than anyone else, and it's important that they make that end-of-life decision. But maybe a spouse isn't financially the best at managing or reconciling a checkbook, and they've made some poor decisions. So it might make sense to have the spouse and another co-trustee along to help or assist in financial matters. There's no obligation, again, to have the patient advocate be the same as your others, but it can be the case. Question here, what is the average cost to hire an attorney to establish a revocable living trust? It varies, but we charge on an hourly basis. You'll typically see estate plans being done between, for husband and wife, right around $2,000, for single individuals around $1,500, and that's an all-inclusive plan. You'll see wills, trust, power of attorney, patient advocate, HIPAA releases, which are medical authorizations, assignments, and deeds. But again, it varies depending on needs of the clientele. But I would say that range I had given is probably the going market rate in Michigan.
Okay, great. And the last question that came in was along the same line. So that's great. And once again, thank you for your time. That brings us to the conclusion of today's webinar.